I'm Anie Mayelian.
Hi, and I'm Aleen Mayelian, and we're from the Mayelian Group. Welcome to our program. This is Kim Cameron. Thank you for being on our program. We really appreciate it. She's a landlord-tenant attorney, and she specializes in evictions. She's done hundreds of unlawful detainer actions, and she currently litigates in LA County. And just to introduce ourselves, we are multifamily agents. We specialize in apartment building sales in LA. And let's proceed. So can you just tell us a little bit about yourself? What do you do? Tell us a little bit more about your practice.
Sure. As you said, my name is Kim Cameron, and I have a firm called Bucher Cameron, LLP. My partner is down in San Diego. And I do landlord-tenant law as one of my main areas of practice. The other main area of practice is wills and trusts, so drafting wills and trusts. So those are my two areas of practice. And we've been in practice for almost 10 years now.
Wow.
Yeah.
That's great.
Very exciting anniversary coming up this year.
Yeah, that's amazing.
Yeah.
Sounds good. So Kim, the landscape of evictions have changed a lot over the course of the last few years. And so what's the current process for a landlord if they want to evict a tenant? What's the general timeline, would you say?
Well, the process really hasn't changed, but the timeline is a little longer than it was pre-pandemic because the courts are packed. So that the process starts with serving a 3-day notice, assuming it's a failure to pay rent. Serving a 3-day notice, and then assuming they don't pay, then you file and serve the complaint. Once the complaint is served, then they'll have 5 days to answer. So that's right there. That's a couple of weeks, and then you have to request a court date. And that's where the delays start happening. So by law, you have to get a court date within 21 days of asking for one. And as of right now, it's usually closer to the 21 days end than the within 5 end. So that's the first court date is that. Once you get a court date, the first court date is rarely, if ever, a trial because the courts will require you to have a conversation to see if you can settle the case before going to trial. And they do this because this is an accelerated process. Regular civil cases, you don't get a court date that fast. You don't have to file an answer that fast. And your first court date isn't for like a year or two after filing the complaint. So this is a whole lot faster. So they require a good faith attempt at settling first. If you're able to settle, then great. If you're not able to settle, then they set another date for the trial, which could be anywhere from 2 weeks to 2 months after the first one. Just, depending on which courthouse and how busy they are. And then once you get a judgment, and if the sheriff has to get involved, then there's further delays because they are also very, very busy with doing evictions, and they have limited resources. I don't know if you've heard that LA County is short-staffed on their law enforcement personnel, so that affects this as well. So, it can be as quick as a couple of months. It can be as long as 6 to 8 from start to finish.
Okay.
Now, are there any courthouses that are particularly better than others?
Pasadena is usually pretty quick in terms of the court part.
Okay.
Downtown is the one that
Longer.
has, if you don't settle on the first day, it's going to be 2 months for the next one. But you don't get to pick your courthouse. The courthouse is dependent on the address of the property
Okay.
and the amount that is owed. So if it's under $35,000, which hopefully any would be, then it's whatever's closest. If it's over $35,000, most of those cases have to go downtown.
I see. Okay. And in terms of LA, City of LA, what are some valid grounds for eviction? What are non-valid?
Valid grounds for eviction: non-payment of rent.
Okay. That's it?
Pretty much it. There are some exceptions. So the just cause requirement that went into effect last year requires just cause. So it's, non-payment of rent is the most obvious just cause.
Yeah.
If there's a material breach of the rental agreement for something else, that would be a way to do it. That would be a valid reason. Then there's the no fault reasons for eviction that we used to be able to do pre-pandemic. Most of them are no longer available. So if you have a lease agreement that has an end date on it, it doesn't actually end. You can't just say, okay, your lease is over, you've got to move out. You with a 30-day or a 60-day notice.
Right.
That is no longer the case. However, if there's now you said you do multifamily, so this probably won't apply much, but a single-family home, there is an exemption for that. And if the owner of the single-family home is an individual person, not a corporation, not a
LLC.
yeah,
Yeah.
then you can use the owner move-in. So the person who owns the property can give notice and say, I'm moving into the property. But with a multifamily, that's not an option. And so there are some other governmental related things that are no fault evictions, but those are rarely, if ever, used.
Okay.
Yeah, and also so that's LA City. The various different cities in the county, whether incorporated or unincorporated, each have their own rules.
That's true, like Burbank, Pasadena.
Right, so Glendale, you can do some things more than LA City, and some of those are the same as LA City. If it's an unincorporated part of LA County, you have more freedoms.
Yeah.
But so LA City is the most restrictive in terms of what you can do, but you really do have to know which area of the county you're working with to figure out what is and is not available in terms of how evicting people.
Got it.
My next question was that, actually, how does it differ in the county of LA?
Yeah. So there are more exemptions. But it's, again, it keeps changing. So I don't want to put anything that is time sensitive on here because it could change next month.
Yeah.
So it's really the best way to go about it is to talk to an attorney,
That's true.
have them check the most recent laws, and then go from there.
Yeah.
Okay.
Yeah.
But the easiest way to evict somebody is if they're not paying rent. If they are paying rent, then it becomes challenging, honestly.
Yeah, that's true.
Yeah, and the other option that is always it's always something to explore is a buyout.
Oh, yeah. Yeah.
Right?
Right.
So if you own a property and you really, really want the tenant out, but they've been really good about paying their rent on time and they haven't violated their agreement in any other way, have a conversation, see if they'd be willing to move
Take
out.
cash?
Yeah, take cash and move out. Yeah.
Cash for keys.
And that's, you do any cash for keys agreement, you have to give them a declaration with information from the city that says what they're entitled to in terms of a buyout.
Yeah. Yeah.
And so you really need to make your offer more than that, or
Right.
at least that amount, and that's based on the number of bedrooms
Yeah.
and how long that they've lived there. And again, each city within the county has different numbers.
Yeah.
But so you have to file a declaration with the city. You have to have everybody sign it and file it with the city, and then they'll have time to, once they've signed whatever the agreement is, they'll have time to change their minds.
Yeah.
Yeah.
Some cities say they have 30 days to change their minds, some say 90 days to change their minds, and it's again, depends on where you are, on what the
City
what
of
the
LA
rules-
is 30, right?
Yeah.
Okay. That's good in a way.
So do you deal with buyouts as well?
Oh, yeah,
Okay.
Okay.
yeah.
That's great.
So you draw up the documents, okay, and you guide the owner of the property.
Yeah.
A to Z. That's
Yes.
good. That's really good to know.
Yeah.
We've had a lot of questions about
Yeah.
that. Okay.
Yeah.
That's good to know.
Are eviction laws different in rent controlled versus non-rent controlled?
Yeah, the rent controlled, there are more restrictions on what, and with RSO properties, you have to be very, very, very particular about everything you do. It's like if there's, one thing that you didn't include then in the notice, in the 3-day notice, the tenant hires somebody who
An
knows
expert?
those rules,
Okay.
the case can get thrown out.
You have to
So-
start again.
Yeah.
That's what you're saying.
Yeah.
Okay. So you've wasted a lot of time.
Yes, and money.
Yeah.
Because every time you file a new complaint, you have to pay more filing fees.
Yeah.
You know, so.
Yeah.
Okay, so are there any defenses a tenant could raise that in an eviction case? What are they generally?
The most common one is habitability.
Okay.
Okay. So roaches and things like that?
Yeah, and the plumbing doesn't work, or the heating doesn't
Heating.
work, or you know,
Yeah.
or mold, or whatever.
Right.
So a lot of the self-help counters and the pro bono firms and other law firms who work with tenants primarily,
Yeah.
they have pre-printed forms of of defenses.
Uh-huh.
So they sit with the tenant and say, all right, check.
Just all of them?
All of them? Even
And
if you
it-
don't
well,
have mold or...
I would assume
Yeah.
that, you know, as good representatives of the law, they would say only check the ones that actually apply.
Apply, right.
So, you know, and a lot of times tenants will check more than actually they can prove.
Right.
So whether they think they apply or not, you know, to raise a defense, you have to be able to prove it.
Prove it.
So you know, when I see the answer to a complaint, I will look and see which kind of things they checked or included if they actually wrote it out. And then I will check with my client and say, okay, is there potentially any validity to this? Have they ever notified you of any problems with the plumbing or the heating or the whatever?
Right. Yeah.
And what did you do about it? Okay, because it is a defense. It is a defense to paying rent for a month if there are issues that were reported and not repaired. What a lot of tenants don't understand is it's only for a month, not for 6 months.
Right.
Okay. Yeah.
Okay. So you have to pay, starting the second month, you have to pay the rent,
And a lot of
even if the
and-
issue is not cured.
And generally, they won't. You know, but you know, so it's something that you know. Before I knew about the law, I would think that, you know, if there's a problem that's not being addressed, that I would say, okay, I'm just not going to pay you. I'm telling you, that I'm not paying you until you fix it. And not worry about how much time it is. But now that I know the law, it's like, okay, I can only use that as a reason not to pay rent for 1 month.
Yeah.
Right. Okay.
Okay.
So are there any steps a landlord can take to ensure the process goes smoothly?
Respond to all repair requests
Yeah.
promptly.
Okay.
That's one. Treat your tenants with respect.
Yes.
You know, because a lot of times one of the things they'll check is harassment. So and that may just be because you sent them a couple of notices and the tenant thinks that's harassment, which it's not.
Right.
But it can feel like it. You know, so when you're serving notices, just be respectful of them. It's like, you had this agreement, you didn't do it, let's get this taken care of. Those are the two main things. And then in terms of, after, once you hire an attorney and are in the process, just, be in communication with your attorney.
Okay.
Okay, so how does a landlord go about collecting past due rent?
Well, that's the thing. You start with a 3-day notice.
Okay.
Okay. And so you serve the 3-day notice. They have 3 days, not including weekends and holidays. So say it's the 4th of July weekend and the 4th of July is a Monday, and you serve the notice on Friday. Saturday, Sunday, and Monday don't count because that's weekend and holiday. So the first day that counts of the 3 days would then be Tuesday. Okay. But once you serve the 3-day notice, they have the 3 days, not including weekends and holidays, to pay whatever the amount due is. If they pay it, great, you have collected your rent. If they don't, you don't have to file the complaint right away. You can allow more time if you're willing to.
Like working it out
I
with them?
actually had one client say, okay, so if they give me the money on Tuesday instead of on Monday, do I have to? And I'm like, no. You can take it if you want to. If you do accept the rent after the 3 days up, then we can't do an unlawful detainer. Okay? But you don't have to file that. You never have to file the unlawful detainer unless and until you are ready to move forward with evicting them.
Okay. That makes sense.
Yeah.
So along those lines, I mean, you just mentioned collecting partial payments. Are there any things that would kind of negate the process, or any examples? I guess if you can talk a little bit more about that, some no-nos that landlords shouldn't do.
Well, yeah, I mean that's the main one.
Okay.
Because once you get to the complaint, you have to say, we served this notice. They didn't comply with it, and therefore I'm filing this unlawful detainer complaint. If you accept rent after you've filed the complaint, then it complicates things. It doesn't necessarily mean it's thrown out, but it certainly complicates things. So I and pretty much every landlord's attorney says, once you filed the complaint, don't accept any more money. Either turn off their portal or return their check or whatever it is. Because once it gets to that point, many tenants will attempt to pay to make this go away.
Yeah.
Now, if you're willing to dismiss the complaint and reinstate them as a tenant, then fine, you can go ahead and take their money. But you would then have to let the lawyer know so that we can dismiss the complaint and do whatever's necessary there on that side. But just best practice, once it gets to going to court, don't accept money. And then, on that first court date, we can come to an agreement. They pay the money they owe and they stay.
Okay.
Or they pay the money they owe and they leave, because legally, once it's gotten past the end date of the 3-day notice, then you don't have to accept the money. You don't have to allow them to stay. And you can. So that's on that first court date. That settlement negotiation can end up a number of ways. It can end up with an agreement for them to, pay what they owe. It could end up with an agreement to pay what they owe and stay. It could end up with an agreement for them to pay what they owe and leave. It could end up with an agreement to waive what they owe, get them out, start fresh. Or it could end up going to trial. There's probably some other options, but those are the ones I can think of off the top of my head. And there's no right answer. It's whatever both sides can agree to. Some landlords say, I just want my money, and I'm willing to, if they can come up with the money, then great, let's carry on. Some landlords say, I just want them out. Whatever we need to do to get them out. So it's just whatever the people involved can agree to is what we put together. And if there's an agreement, then it gets written up. Both sides sign it. Indicating that they are agreeing to these terms, and then the judge reviews it and signs it as well. That makes it enforceable by the courts. So if somebody doesn't do what they have promised, then we can come back and say they didn't do what they were supposed to. Now these are the consequences.
Non-payment again the next month, for example.
Exactly.
Then it's really easy.
Right. So if they don't move out on time, or if they don't pay as agreed, then you come back to court and say that deal's off. Let's enforce it. Let's get the sheriff now.
Okay.
So in those cases, you'll have a judgment, or they'll continue to get a judgment? Is that?
Yeah. So when you have a settlement agreement, either it's the judgment is entered on the day it's signed, but enforcement is stayed or held off, deferred, until some certain date in the future, usually a move-out date, which is anywhere from 2 weeks to 3 months from the date that the agreement is signed. So judgment entered now, stay enforcement until the move-out date. Sometimes the agreement says, okay, we're making this agreement, we're going to trust you to do what you say, and we're not going to enter a judgment until you don't do what you said. sometimes when there's a lot of money and a lot of background, it's sometimes easier to do enter the judgment only on default because they'll make a couple of payments. It'll change the amount of money that is owed, and you enter the judgment when they default with the right amount of money when they default, rather than having to change all that later. So it can be judgment entered now and wait, or wait to enter the judgment until they default.
Okay.
Yeah.
What are the chances of success with a settlement to get
In
a
terms
settlement?
of getting a settlement? Oh, I'm pretty good at it.
Yeah.
And a lot of the people that I work with, a lot of the attorneys, we're all, I would say probably 80%, and that's just a guess.
Wow.
Settle
Okay.
in some form.
To avoid the lengthy court process.
Yeah, because going to
costs.
trial is, as I said before, it adds time automatically. If the tenant requests a jury trial and either pays or waives the jury fees, they get one. So that adds time as well. So because a bench trial is just with the judge and can be scheduled sooner. Jury trial, you have to wait until there's a courtroom that does jury trials and does not already have a jury trial book. And jury trials are the general estimate is 3 to 5 days. So if you've got 10 jury trials ahead of you in the one courtroom that does jury trials, that's already another 10 weeks before you can get to you.
Wow.
So they don't wait that long. And the jury trials can be anywhere in LA County. So say you filed your unlawful detainer in Pasadena and the tenant demanded a jury trial and you don't reach a settlement, so you get, you set for a jury trial, you could end up in Long Beach during your trial. You could end up in Lancaster during your trial, or you could be in Pasadena during your trial. It's whatever courtroom is available. So
It sounds like time. It's like buying time.
a lot of times, yeah. I mean,
It sounds like they're going to move out at the end, but they're just buying time. No?
yeah. Yes. It's a tactic. It's like, and when I have represented tenants, I always say, all right, we put in the jury demand. They're like, do we want a jury trial? I'm like, it doesn't matter. We put in the jury demand because that automatically gets
Lengthens the process.
some time and what most people use the time for is to come to an agreement before we actually do the trial, because the trial is expensive. It's 3 to 5 days. It's it's not like it is on television. It's not fun for anybody.
Yeah.
Right? It's a lot of lawyers' fees. It's jury fees. It's and then the other thing is that at the end of it, if the landlord wins, then the record can't be sealed. Won't be sealed. And if the landlord wins, then the tenant owes all the money, or whatever portion of the money that the jury decides that they had owed, and there's no allotted time for them to move. It's this is it.
Right
We're done.
Yeah.
You're out. You've got to pay the money, and the record is open. Making an agreement is good for the tenant because they can get the record sealed, and they can get.
You're talking about making a settlement.
Settlement agreement.
Okay.
The settlement agreement allows the tenant to get the record sealed. It allows the tenant to have some time to move out. And depending on what the landlord's willing to do, may allow them to may allow some of the money to be waived. And some landlords don't want to do that, which is fair because it's their money that they're owed.
Yeah.
But one of the things is that I always tell my landlords is agree to the sealing of the record because it doesn't cost you anything, and it helps your tenant move out because their next landlord won't know that this happened.
Yeah.
Oh, okay.
And it
That's
probably
what
helps
the sealing is.
the tenant want to settle too, right?
Yeah.
So you're saying that unlawful detainer will not show on their credit report? Is that kind of?
The credit report, I'm not sure. I mean, if there is a money judgment, if there's a judgment for the rent
That will
owed,
show.
that amount of money will show up. But the fact that it was an unlawful, that it was an eviction,
Okay,
won't.
that's sealed. Okay.
Yeah.
So the next
Yeah, and
landlord
the
will
court
not.
case won't be, the court case won't be discoverable if
Oh,
if the
wow.
record is sealed. So the only people that will know about it, as what I tell
Just the parties.
is
Immediate parties.
the landlord, the tenant, the judge, and the lawyers. That's it.
Okay.
Nobody else can ever know that it will happen if the record is sealed, and that helps come to a settlement to include that.
Yeah.
So if the landlord wins, what are the chances of collecting the back rent?
I mean, the same chances as anything going into collections.
Yeah.
Because if the landlord wins or if there's a money judgment, what happens is that money, if the landlord decides they want to enforce that judgment, the money judgment, then it's going to collections, and the tenants can raise whatever defenses they would normally raise to any sort of collections action.
So there's different collections lawyers or people.
Yeah, I don't do that.
Yeah. You're already doing enough. So.
Yeah, and that's I know that a lot of times landlords don't want to waive the money because it's their money.
Yeah.
But if everybody knows that this tenant hasn't paid the rent because there is no money,
They're not going to.
they're never going to pay. So if that's the thing that's holding the deal from happening, I always recommend, write it off on your, however you write things off.
Yeah.
Waive the money, and let's get this deal and get them out so you can start fresh.
Yeah,
Right.
makes sense.
And
That's the best
and there's some landlords that just won't do that, and which is fair. They do have a right to at least attempt to collect that money. But I always, if it is a situation where there is no money to be collected,
Yeah.
we
They don't have a job or.
Right. I mean,
Or a bank
we can
account.
get the judgment. It's going to be a worthless piece of paper.
Yeah.
But we can insist on the judgment if you want to. And and if it's a lot of money, you may want to.
Yeah, that makes sense.
Okay.
Okay. Well, that answers a lot of our questions.
Thank
Our
you so
viewers
much.
will have good information. Thank you so much. We appreciate your time.
Well, thank you for inviting me. This has been fun.
Yeah, thank you. Kim's information will be provided in the description below along with ours. So if there's any questions, please don't hesitate to reach out. Thank you again and have a nice day.
Yeah.
Thank you.